Mr. Corn, you were Mr. Rooks' trial attorney at the trial.
I was.
And just for a little bit of background for the record, would you go ahead and give us a little history of yourself?
It goes back a ways. I graduated law school in 1987 from Florida State University. After that, upon my graduation, I clerked at the Florida Supreme Court for Justice Gerald Kogan for 2 years. That was the duration of the clerkship. From there, I worked at the Leon County, Florida, that's Tallahassee Public Defender's Office. Started in appeals, then moved on up and eventually was worked in every division. By the end of my 8-year run there, I'd done a couple capital cases, death penalty cases. Moved here to Georgia in 1987, where I worked for about a year at the Fulton County Public Defender's Office. Went out on my own in Cobb County where I lived, opened up an office there. Did mostly indigent defense since Cobb County does not have a public defender system at all. Tried many cases, murder cases. I've also worked at in 2013, I went to work for the Georgia Justice Project, which is here in Atlanta, trying cases here in Fulton County and in DeKalb County. And I came back to work here at the Fulton County Public Defender's Office in 2018, about middle of the year. I was hired as a backlog attorney, in which the job was to handle older cases, at least a year old, which at that time seemed like a long time. Nowadays, it's pretty new. Cases that have been indicted for more than a year, and Mr. Rooks' case was one of those. I tried all those cases except for a couple which ended up being pleas. Mr. Rooks' case was the last of those. I had already been transferred to a courtroom where I worked with in Judge Ingram's court, and then I was in Judge Whitaker's courtroom. I've been here just over 5 years now.
Let's start with what we were discussing prior to you taking the witness stand, and my references to the page 6 of the amended motion for new trial. The transcript, and I recognize you don't have the transcripts with you and probably have not seen them. Volume 6, page 178 indicates that Mr. Rooks was sentenced to life in prison. And then the final disposition indicated that it was life without parole. Do you remember any of that?
Unfortunately, I do remember, and I got to tell you, I believe the transcript was incorrect. I remember specifically being crestfallen when the judge said life without parole, because for one thing, Mr. Rooks's age makes either sentence pretty much a life without parole sentence, or very close to it. I just thought, man, a light at the end of the tunnel here would be great, but that didn't happen. My recollection of the events was it was actually a life without parole sentence.
Which does bring up another question. Mr. Rooks has many times said to me that his transcripts are not accurate.
I can't speak to that. I haven't seen them.
Okay. Turning then to page 7 through 9 of the amended motion for new trial. Looking at those pages, any comments, response, whether you should have objected to any of Detective Liam Botcher's testimony?
I'm sorry, which page on the initial motion?
7 through 9.
Detective Liam Packer did tend to go off on a narrative. I would say quite a lot. I feel like I objected a couple of times, but he would always go back to it. The hearsay that I did not object to, I believed the witness who those statements were attributable to was testifying. So I didn't, it was hearsay, but I didn't think it was anything that was going to get dealt with right then unless the witness didn't testify. But they did, pretty sure.
From what you say, this detective was an experienced police officer.
Detective Liam Packer, yes.
And he knew how to testify in court.
Oh, for certain.
Would you agree then that probably included the narrative testimony as a way to get across everything he wanted to say?
Yes.
which is not necessarily good for the defense.
It's not, and it was frustrating trying to slow him down. He didn't do it. He, as I recall, he didn't really do much in the way of answering my questions, yes or no either, because he knows how to testify.
Turning then to page 10, any comments there so far as whether you should have objected to some of his opinion type of testimony? I'm talking about what he said so far as the 911 call and then also financial records.
I probably should have objected to that, yes. I don't recall that I did.
Which again falls in line with what we just talked about with this detective getting into evidence everything he thinks he can.
I'm sorry, what was the question?
This is again that detective,
Yes.
the way he does it.
Just so I'm clear, Judge Hort, you are calling it improper opinion testimony if a witness is asked, were X, Y, and Z consistent with A, B, and C? And here's a situation where Liam Packer simply said yes. That's all. A one-word answer. He said yes. Help me understand how that's an improper opinion. It's not. Did you think Mr. Rooks was a bad guy? That would be an improper opinion. But did you look at A, B, and C and compare them to E, F, and G? Were they consistent with each other? That seems like that's within the realm where I don't know, because there was not an objection. I might have looked a little funny at Mr. Korn and said overruled. But I may be missing something.
Well, what I am relying on, and I recognize that I am not the experienced Fulton County attorney that all of you folks are, is this was a detective that was, one, determined to get everything out he could against my client, and two, was an experienced law enforcement officer that I assume and believe had great credibility with the jury. And anything that he said that would corroborate some other piece of evidence is something that carried significant weight against my client. And yes, you may have said overruled, but in the same vein, you might have said, come on, detective, let's just keep it to what you yourself
Sure.
personally know.
And we don't know. I'm clearly speculating by saying what I would say because there was not an objection.
And to me, it was even more important with the financial records. Financial records can be convoluted. It can be difficult to understand. And when you have a detective then that gives you a basic summary that in essence indirectly implies your client's guilt, to me, that's something worthy of an objection. I guess I should ask you, Mr. Korn, any disagreement with that?
I didn't feel like what he was talking about with the financial records was specifically opinion. I thought he was reviewing the numbers. I didn't object to that.
Turning then to page 11, still on the amended motion for new trial. Your comments, your thoughts, whether you should have objected to the state's closing argument using what jurors had said during voir dire.
I should have objected to that. I objected to other things. I did not object to that. And I should have.
Pages 11 through 12, still of the amended motion for new trial. Your comments, thoughts relating to the question by the jury during deliberations. What does an abandoned and malignant heart mean by definition of the law? Your thoughts there.
Can you, for the record, frame what's the concern? So it's a juror question, and you made clear not the, in some minds, controversial during trial, as in not yet deliberating question, but this is jury deliberations. They write out a question, as they should in any trial, and their question was about what an abandoned and malignant heart means. I said whatever I said in the transcript. What is it you're saying Mr. Korn did or didn't do, since we're in the ineffective side of things?
Thank you. And Your Honor, if I'm quoting you correctly, you said, and my thought is that the answer is the words have the meaning that you give them, or something to that effect. My questions of Mr. Korn are as such, looking at the Georgia case law, they talk about brutal and bloodthirsty. And to me, this offered an opportunity for Mr. Korn as his trial attorney to get that understanding with the jury. We're not just talking about some person who horrifically, tragically died, and her son may have something to do with that. The question was this brutal and bloodthirsty. And I think that's what the jury was asking when they asked that question. we've got a concern. What does abandoned malignant heart mean? And I think this offered an opportunity for Mr. Korn, recognizing you're during trial and it's not easy right then and there to do the research.
Right.
But an opportunity for him to explore that a little bit and try to get something to the jury that would emphasize that his client was not brutal and bloodthirsty.
Okay. To be clear, I was not aware of the case law that suggested that an abandoned malignant heart was defined by brutality and bloodthirstiness. So I didn't interject any proposed instructions to that effect. I thought that the rule was they had to go with the pattern instructions the judge had already instructed. And I didn't feel like it was a great idea to go away from that. I felt like it would probably raise more damage than it would do. But if that case law was out there, I probably should have been aware of it, and I should have used that to my client's benefit. I've never thought this was a malice murder case.
And I'm sorry.
I've never thought this should have been a malice murder case. I thought they could maybe prove felony murder. I did not think this was an abandoned malignant heart murder case.
And I guess my thought is that even not having that case, the words abandoned and malignant heart would seem to offer an opportunity. Judge, we need to instruct them that what does malignant heart mean, and come up with a definition that shows it's much more than murder. And that gets back to that malice again, to try to amplify that this was not a malice murder. Worst scenario, there is some connection, there is some responsibility, but not to the degree for which he was facing the trial.
Right. And I could have argued that. I've never had any judge once ever give anything but the pattern instruction on that. So I probably didn't look at it as deeply as I could have or should have.
And you would agree, and I'm trying to bolster the court, but Judge McBurney is one of the few judges that will actually listen to suggestions, discuss it with you, and do what he believes to be appropriate in the interest of justice.
Yes.
Turning to pages 16 through 17. Your comments as to whether you should have objected or moved to suppress the recording by law enforcement of Mr. Rooks when he was on his cell phone. This is when he went and was talking to the police, and then he was in another room, and then he was on his cell phone.
Okay. Oh, you mean in the interview room? Because there was
Right.
also a cell phone call when he was at the scene.
Right.
I did not move to suppress that phone call.
And I recognize my colleague has pointed out a plethora of cases that indicate there's no right to privacy, no expectation.
I didn't anticipate that he had any expectation of privacy in that room.
Don't you think in reality he probably did? He didn't think
he may
anybody-
have thought he did.
And
I'm sure he thought he did.
And it might have been a reasonable expectation that I'm here in the room by myself. They're not, police wouldn't eavesdrop on me. They wouldn't have this room bugged. I've got an opportunity. I can talk on the phone in private.
All right. I didn't object to that. I thought that police interview rooms were kind of fair game.
Like the back of a squad car.
Exactly.
Okay, turning to page 17 and then also pages 18 and 19. I want to talk to you about the medical examiners and also possible defense experts. Your comments, thoughts as to whether you should have subpoenaed one or other medical examiners who concluded that the manner of death was not a homicide, whether you should have subpoenaed them at trial.
I think that would have been a good idea that I did not do. I wasn't sure which ones were. I could have found out, obviously, by just talking to, and I had many conversations with the medical examiner in this case. I probably could have found out who were the objectors. I know that the chief medical examiner was no longer there, and I don't think he's even at state anymore. The person who was the chief medical examiner at the time. As to whether I would have called my own, I did employ Dr. Sperry to testify at the motion with regard to the loss or destruction of the evidence. which ended up being found. And I did speak with him extensively about dementia and dementia-related illnesses. And he made it pretty clear that even though a lot of death certificates will say dementia or Alzheimer's disease, that's not directly a cause of death. And he's a pretty experienced, an extremely experienced medical examiner, and is as close to the top of the forensic world as you can get, at least in this state.
I guess my thought is, one that's maybe reference to your concerns so far as him being charged with malice murder. It may be reference what I mentioned earlier, this malignant heart, or it may be something just for the jury to understand that what happened here, Mr. Rooks was not perfect, but is he really guilty of all the things that the state alleged in the manner they alleged? Should he be found guilty, i.e. of malice murder? I guess that's my thought. If you had that medical examiner, if you brought on some expert witnesses, maybe they could help the jury understand what happened here.
Unfortunately, we have a fairly limited budget, and I had already employed Dr. Sperry, and I thought to good use, except he did testify that Alzheimer's and dementia is not a direct cause of death. It can be approximate cause of death, and of course, approximate cause of death is enough for felony murder. I believe that Jackson's the case. We just don't have the budget to employ more than one expert per case.
So in terms of effectiveness, as I'm understanding it and recalling it, you in fact did retain an expert. I think we had to delay the proceedings a couple times because of some of the budgetary constraints you described, but you persisted. You did obtain an expert, Dr. Sperry, and the expert who it sounds like by everyone's acknowledgement is exceedingly well qualified. I'm shorthanding here. He didn't give you the answer you were hoping for. And so I guess you could keep knocking on doors of other experts, but you went pretty close to the tippy top of medical examiners. And when you had a chance to fully explore it with Dr. Sperry, my understanding is you elected not to call him during trial because in the end, the prosecutor would elicit from Dr. Sperry, that's not a causation situation. There's a connection. You wouldn't be where you were, like the victim was, with no dementia, no Alzheimer's, but that's not the cause of death.
Right.
Is that a fair summary of what I think we litigated? Okay.
And Dr. Sperry and I had many conversations on this point. I tried to get him to move towards, again, like I never thought this was malice murder. I thought that the state could maybe prove felony murder, and obviously did prove felony murder, but I thought that once the autopsy photos were in, we were losing everything anyway.
This doesn't negate that it still would have been worthwhile to call one of those medical examiners that came up with a different conclusion than the one that testified at trial.
I mean, I think that could have been useful, yes.
And remind me, Judge Hort or Mr. Korn, I think it was the retired medical examiner, Henninger, testified at trial. That, but it was his testimony that, this one was really complicated and I kicked it around with some colleagues and we weren't unanimous in our perspective on this. This is what Judge Hort's getting at, that there is someone out there who might have had a different perspective than Dr. Henninger on some aspects of the report.
That's my recollection of the testimony as well. Dr. Henninger was, he was of the belief that homicide was the manner of death, but he said he was overruled on that by at the time, I believe the chief medical examiner.
So the jury got to hear, not from the mouth of a dissenting or disagreeing medical examiner, but from the person who performed the autopsy, hey, there were conflicting views. It's not that the jury didn't hear that, just to Judge Hort's point, they didn't hear it from those who disagreed.
They definitely heard that there were conflicting conclusions.
Okay.
And the science is not perfect on it. It's just not there. And a lot of this is a lot of detective work.
Notwithstanding Dr. Henninger's testimony, would you still agree that it would have been beneficial to have those other medical examiners investigate them, talk to them, and bring them in actually as witnesses so they're not just hearing in passing?
I believe that it would have been useful, yes.
Now, did I misunderstand Dr. Sperry's testimony at the motion? I thought he had said that if there was evidence of severe dementia, that could lead one to conclude that the manner of death was natural causes. Did I misunderstand that or misread that?
I don't recall a specific testimony now.
That's fine.
That was a long time ago.
Sure.
That was just over a year ago. That was even longer before that.
And you've had a few cases since then. I guess my question then is to follow up whether it would have been helpful, even notwithstanding what Dr. Sperry told you, to have an expert come in, evaluate the mother's prior medical records, financial records, connection to her dementia, and the natural causes of her death. And again, getting back to whether this is a malice, getting back to his culpability, it just seems like that for the defense, that would have been good still to have that expert come in and look at all the stuff the state presented and say, wait a minute, this isn't the only conclusion.
It would have been useful, yes.
Would you agree that an expert could have talked about the mother's dementia, her absolute refusal to receive medical assistance or inpatient care, and the stress this could have on family members?
An expert could have testified that that happens. That's about all. Mr. Rooks testified that it did happen. That she absolutely did not want care. She did not want to go to the hospital. She did not want to go to a nursing home. She was very, very adamant and said, this is where I want to live the rest of my days.
Then an expert could have come in and said, hey, this is what happens sometimes with dementia. A parent can be completely unreasonable in their demands, and what's the kid going to do?
It could have been helpful, yes.
Okay, turning to page 18, still of the amended motion for new trial. We've already talked about the narrative. Let's talk about whether you should have made any type of motion to redact the testimony of the detective, Liam Parker, telling defendant what he understood the law to be.
When you say redact, what do you mean?
That doesn't go in front of the jury.
In other words, once Mr. Korn heard it, he should have moved to strike.
No, even before the trial. Once
To
he
the
knew
file a
this,
motion and limine on that.
right, I'm sorry, yes, a motion.
Okay, because when I hear redact, I'm thinking there's a document. Was there a document that was tendered that had that in there? Or you're saying it should have been, I should have entered it, well, Mr. Korn should have asked me to enter a ruling saying, Detective Liam Packer, don't talk about the law.
I got to get you more familiar with Michigan law. He said it correctly, the motion to eliminate.
Okay,
I think he's talking about an interview tape,
okay.
not live testimony, but the interview tape. that
When
took place.
Liam Packer was interviewing Mr. Rooks, there was some discussion about the law.
That was my understanding of what the claim was.
Okay, and then the motion to eliminate would be, hey, if it's going to come in, assuming Jackson Deno works in the state's favor, but this part shouldn't come in because it's not relevant or it's whatever the reason would be.
Yes.
Okay,
I should have moved in limine to have that.
And recognizing the court did instruct the jury that the only source of law you're going to get will be from me at the end of the trial. Would you agree, as an experienced lawyer, sometimes just getting out in front of the jury is enough, no matter what the judge says so far as disregard?
Yes, I would agree.
can you remind me, Judge, what kinds of things was Detective Liam Packer saying about the law that would have been problematic? I just don't remember.
Let me see if I can.
It's not critical. I'm sure, I trust you cite to that and I'll find it. If anyone remembered off the top of their head, if he was saying, this is what murder is, and you have an abandoned and malignant heart.
Yes, Your Honor. On page 61 of the state's brief, I outline all of it very well for you.
All right, 61.
Right?
Thank you.
You're welcome.
Okay, thank you.
You're welcome.
I'm sorry, I didn't mean to cut anybody else off.
Nope,
Was
you're
anything
good.
else?
I had cut you off.
Okay. Okay, let's then turn to the second amended motion for new trial. Page 2. Your comments, thoughts as to whether you should have pursued a motion challenging the probable cause for the magistrate to issue the arrest warrant.
Well, here's this, as I testified earlier, I came into this case late in the process. I think I may have been the fourth or fifth attorney for Mr. Rooks. When I was handed these files to just clear, try, or resolve, I was told everything had been resolved. There were no further motions that need to be filed. It's ready to try. You just need to get up and do it. I obviously did file another motion on Mr. Rooks' case in that we did have a concern about the missing brain tissue evidence, but beyond that, was under the impression that stuff had already been reviewed, and I didn't see anything facially wrong with it. I also thought that once probable cause was found by a magistrate in a preliminary hearing, kind of negates whatever the affidavit says in the.
Right, or an indictment. I'm curious what would be suppressed?
If the arrest was illegal, then what follows as the fruit of the poisonous tree.
Oh, so he was interviewed after this interview we were just talking about was subsequent to. Pro se defendants often say, oh my gosh, I want to suppress my arrest warrant. And I explained, one, I don't think the jury's ever going to hear about it, but two, any issue with the probable cause to arrest you has been cured by a preliminary hearing or an indictment, et cetera. But you're exactly right. If as a result of the arrest, they found in his pocket the keys to something that was critical, then that's fruit of the poisonous tree. I just wasn't recalling that anything flowed from the arrest other than now we have the body. Of course, then Mr. Rooks was on bond for a zillion years. So was this interview that we were just talking about what occurred right after the arrest?
If I may, this was an issue asked by Mr. Rooks for me to raise.
Okay.
And I'll explore that with him when he testifies.
Okay, thank you.
Page 18, whether you should have filed a motion challenging the search warrant.
So there's not a page 18 in your second amended motion?
Oh, I'm sorry.
It goes to 5.
It was short and sweet. It was only 4 pages.
Remember last time I had the motion, it was one that was filed with the court.
Yep.
And I actually have 2 copies. They're both.
Okay, be page 2.
Okay. I did not file a motion to suppress with regard to the search warrant. No, I wasn't aware there. It didn't appear to be on the surface there were any problems with the search warrant.
I guess question number 1, looking at those documents, doesn't it kind of appear that the law enforcement had already did a search of the house to even name some of those things in the affidavit or in the search warrant? Food, pill bottles.
I don't think they went into anything that wasn't in plain view. I mean, they were called there because there was a deceased person inside and they needed to be inside for that reason. But as far as I could tell, everything they were talking about was in plain view.
All right, for example, food from looking in a refrigerator. Pill bottles, normally we all keep pill bottles in the bathroom.
Yeah, but I'm remembering in this case that pill bottles were on like a windowsill or that I'm remembering
There
pictures.
was a video of it.
Yeah.
They were definitely in the open. Now there were orange, there was food in the fridge, but I wasn't going to file a motion to suppress the food.
But just to suppress the search warrant because of the improper search prior to the affidavit. Like, for example, wasn't my memory that there's all sorts of piles of paperwork in the room. Seems like by the wall, there was all sorts of documents.
There were, and I don't think the search warrant specifies which documents they were specifically had seen prior to or after the search warrant.
But I guess my question again is whether law enforcement had gone through those documents and then went and got the affidavit.
I don't know the answer to that question.
That's fine.
Like I said, a lot of this stuff was in plain view. Ms. Rooks was a bit of a hoarder. That's hoarder, not the other word.
You talked about your concern with the transcript may have been misworded. Did you ever see that at all in any of the documentation that you received from the state in discovery?
Not that I recall.
Is it anything that Mr. Rooks ever mentioned to you that this isn't right, this isn't how it happened? Anything like that?
I want to say he probably did with respect to how things played out at his home before, or at his mother's home prior to his arrest, but I don't remember specific. Him saying that didn't happen that way, at least not anything specific in the reports.
Thank you, Ryan.
Okay. Ms. Elam, do you have any questions for Mr. Korn?
Yes, sir. Briefly.
Sure.
Good morning, Counsel. Okay, I'm just going to ask some general questions and then I'll get into the specific questions regarding some of the claims, okay? Outside of Florida and Georgia, are you admitted to practice anywhere else?
I'm no, first of all, no, and I'm no longer practicing in Florida. I no longer have a license in Florida.
At the time that you tried this case, were you still licensed in
I
Florida?
was, yes.
Okay.
It
So
was
at that-
inactive.
Inactive, okay. And you testified that at the time you tried this case, you were in the PD's office of Fulton, correct?
Yes,
Alrighty. And it's fair to say that at that time, majority of your practice was criminal?
100%.
Okay. Do you recall or can you estimate around that time how many defendants you had represented in jury trials where a verdict was reached?
Dozens.
Okay.
I can't be sure. It's been so long. It's over 30 years of trying cases. I'm not the sort of person who counts, so it's a lot.
A lot, okay. Do you know how many of those cases were murder cases?
I want to say 15 to 20.
Okay. And how many of those cases were elder abuse cases?
This is the first murder, but I've had other elder abuse trials. I would say maybe 3 or 4.
Okay. And were those 3 to 4 cases here in Fulton?
One was in DeKalb. I've had a couple in Tallahassee, but I've had more than a couple here that have been to trial.
Okay. At the time that you were in the PD's office in Fulton when you tried this case, how long had you been there?
4 years,
Okay.
that office.
All right. I'm going to briefly talk to you about your preparation in this case. Did you meet and consult with your client before and during trial?
Many times.
All right. How many times did you meet with him?
I don't have my file in front of me, which documents these things, but more than 15, I would say, but probably less than 20.
Is it customary for you to meet with your clients that many times or that often in a murder case?
As much as possible. Mr. Rooks had been bonded out. And at that time, I'd been representing him just about the full 4 years I've been at the office. So I'd say that's probably more than usual. Most of my clients charged with murder have been in custody. A prior attorney had done a superhuman job of getting him a signature bond on this case, so he was out. But I would say that's about normal for somebody on bond.
Is it fair to say that you thoroughly discussed the case with him?
Yes,
Okay. Did you investigate the facts in this case?
yes.
Did you have,
Multiple investigators working the case.
thank you. Did you have any assistance trying this case? Another attorney, law school intern?
Yes, no, I had another attorney working with me full time on it. That was Rachel.
Gordon?
No, not Gordon. I'm blanking on her last name though. I always just call her Rachel, but she's actually another supervisor in our office still. She supervises over state court, but has done a great number of felonies as well.
Okay. Any law school interns?
No interns.
Okay.
Rachel Jenks?
Yes. Thank you.
Thank the transcript.
It's my brain, my old man brain.
If you can recall, was your client able to name any helpful witnesses?
He named a number of witnesses. They were not as helpful as he thought they were.
Did he
Yeah,
tell you?
names, addresses, phone numbers. We talked to them and had investigators speak with them.
Thank you. Did you have an opportunity yourself to speak with those witnesses or
Yeah,
just your
I spoke
investigators?
with myself.
Okay.
Along with an investigator. Sometimes I just picked up the phone if I had a question. They were usually happy to talk to me, which is pretty unusual.
Mr. Korn, just make sure you don't start answering till Ms. Eaglin's done. You know exactly where she's going. This is a very standard examination, but the court reporter is going to have trouble creating that accurate transcript. So wait till that final punctuation mark.
Okay. Did you obtain discovery from the state?
Yes,
Did you thoroughly review that discovery?
yes.
Did you yourself obtain any other evidence in this case outside of what was provided by the state?
Yes,
And you thoroughly reviewed that evidence?
yes.
Did you turn that evidence over to the state?
Mostly it involved the missing brain tissue. The state alerted us that the brain tissue had been found, and they turned that over, and I turned over to them essentially the report of Mr. Sperry, Dr. Sperry's investigation of it.
And in your professional opinion, was this helpful to the defense?
I thought it was.
In what way?
Well, it demonstrated the shoddy practices of the Fulton County Medical Examiner's Office in losing it to begin with, and kind of miraculously finding it on the eve of trial. Dr. Sperry was very detailed in how this should have gone down, as opposed to how it did go down. And I thought that was helpful in our motion.
In your professional opinion, do you think that this helped refute some of the state's theories in this case?
It dealt with causation, so yes, I'd say so.
Okay, moving to some of the claims. We'll start with the claim regarding the calls that the defendant made at the police station. You testified that you did not file a motion to suppress because you did not believe that the defendant had a reasonable expectation of privacy at the jail, correct?
That is correct.
Are you familiar with the Georgia eavesdropping statute?
I am.
Okay. Were you familiar with that statute at the time of trial?
Yes.
Okay. And you testified that you did not believe that there was a reasonable expectation of privacy. Is that your belief as it concerns an interrogation room at a police station?
Very definitely.
Okay.
Everybody knows those rooms are rigged for recording.
Okay, so it's fair to say that in your professional opinion, you did not believe the police station was considered a private place within the eavesdropping statute, correct?
Correct.
Okay,
In fact, I'm suspicious when an examination or interview happens and there's no recording.
That's how far we've gotten, is that it's, unless it's the FBI, how is this not recorded?
okay, so then is it fair to say that, let me just ask you this, did you believe that the evidence that the state admitted that was a result of those calls that he made, did you believe that this evidence was inadmissible?
I did not,
Okay, why?
because Mr. Rooks did not have a reasonable expectation of privacy in the interview room.
And did this play a part in why you did not object or move to suppress the recordings?
Yes.
Do you believe that these phone calls were harmful to the defendant?
I really didn't. They just kind of, they didn't say anything like, I finally did her in or anything like that. He was essentially just telling what happened, which was consistent with what he's been saying kind of all along.
Okay. Had you thought the calls were harmful, would you have tried to prevent them from being admitted?
I would have tried, yes.
Okay. So it's safe to say that you didn't necessarily have a strategic reason for not objecting. You just didn't think it was something that was objectionable.
Right. I think most of the conversation had to do with dealing with what follows the death of a parent, in that you have to deal with the funeral homes, the insurance, the everything to get the estate squared away. And that seemed to be his primary focus of those phone calls, if I'm remembering correctly.
Okay. Moving along to the claim alleging that you failed to pursue evidence to refute the state's case. We just briefly talked about Dr. Sperry and the evidence that you sought to admit that ultimately was admitted in this case. Do you feel as though you needed additional time to investigate in this case?
I do not. We'd spent years.
And do you feel that there were any additional witnesses that you needed to subpoena?
Like I testified previously, we did interview witnesses that Mr. Rooks believed would be helpful, and they just weren't. So no, I would not have subpoenaed any other witnesses.
Did you thoroughly review the medical examiner's report?
Very thoroughly.
Did you understand the report?
Yes. And whatever questions I had asked Dr. Henninger.
Was anything alarming to you about the report?
There were a couple of notations that needed to be investigated further. I wouldn't use the word alarming. There are certainly some red flags raised by statements made in the report.
And when you saw those things that were, you said not necessarily alarming, but questionable, who did you speak to about that? Did you speak with the doctor who
Spoke
performed?
with Dr. Henninger, and then I spoke with Dr. Sperry, the expert we'd hired.
Okay. After speaking with both of those individuals, did you feel there was a need to speak to anyone else regarding the issues you may have had?
At the time, I didn't. I probably should have spoken with the other doctors in retrospect, but hindsight is like that. The other medical examiners who felt differently from Dr. Henninger.
Okay, so you testified that you did speak with Dr. Henninger.
I did.
Great. Is there anyone else that you spoke to in the medical examiner's office about this particular case?
I did speak with the investigator who cleared up, essentially just I asked him some basics about his performance in the case. That's the only other person I spoke with.
Okay, so it's safe to say you did not speak with any other doctors?
No.
Okay. Did you feel that there was a need to speak to other doctors?
At the time I didn't. I think in retrospect, I probably should have.
But at the time, you did not feel that way. Why?
The report said what I wanted it to say. I didn't want to go too deeply into it. It didn't lead, it said the manner of death was undetermined. And of course, we had the whole investigation concerning the missing slides. But beyond that, what more was it going to say? I mean,
Is it
what
safe?
were they going to say that was going to say was undetermined?
Is it safe to say then that you believe the report to be helpful to your
Yes.
client?
So I guess I sort of misspoke. The dissenting view was really the witness the state called, because now I'm remembering, in the end, because of the committee approach that occurred with this particular autopsy, the collective or the majority vote from the Fulton County Medical Examiner's Office was that cause of death was undetermined, or whatever the terminology was. It was Dr. Henninger who said, I think it was something different. And you were able to say, right, okay, and he said that. But you had the report to say, well, that's not what your report says. That wasn't the majority view of your colleagues there. Okay.
Okay, moving on to Detective Leon Patrick's testimony. You testified that you did believe that his testimony was somewhat narrative at times. Do you believe that he was testifying to what his investigations revealed?
Yes, I think that his testimony was consistent with what his investigations revealed. I thought I should have slowed down his role a little bit. Because let's face it, that Detective Lampacker definitely got an A in the class about testifying. So I should have done more on my part to say, objection, you need to not put this in the narrative.
So
Ask questions, answer questions.
would it be your testimony that his answers were non-responsive then?
They were a narrative, which is not proper.
At the time, did you believe that?
Yes.
So it wasn't the substance so much as, if I'm simplifying here, I think there's the format. As you said, you needed to slow down his role. He's off and running, and he's persuasive. He's making eye contact with the jurors, and they're swept up in the story. And your regret now, your acknowledgement, is that I should have forced that to be broken up. So it's still get the same information out, but it's staccato. It's humans don't process it the same way. And the prosecutor has to take it piece by piece rather than what happened next. And we go through the next 42 hours rather than the next 30 seconds.
I think that's fair to say. It was a question of form. The evidence was coming in with there were some exceptions where I probably could have kept it out. But for the most part, this evidence was coming in, and I just let it happen in a way that was way too credible, way too easy for him. I should have made it harder for him.
And that leads me into my next question. At the time that you tried this case, did you believe that he was testifying about evidence that was cumulative of other admissible evidence?
When he testified as to what other detectives did a little bit, yes. But the other detectives were testifying, so not much I could do realistically about it.
So was that your strategic reason for not objecting?
Yes.
Okay, moving on to the pretrial motion claim that you should have filed a motion to appellate counsel used the word redact, but we know that this is a video at issue of Detective Lampacker kind of explaining to the defendant what he thought the law to be. In this case, the court provided a curative instruction after you lodged an objection. Do you believe that the court's curative instruction was sufficient?
Honestly, I don't remember.
Okay.
But this is helpful context. And again, I'll dive into the transcript when I'm working on my order. What your review of the transcript showed you, Ms. Eaglin, is that when that segment of the interview occurred and Liam Packer starts talking about the law, Mr. Korn objected. And then I said, whatever I said about you don't get the law from Liam Packer, you'll get it from me later on. Whether that's sufficient or not, I'll need to work through. But there actually was an objection. There wasn't a motion to eliminate in advance of trial, but there was a real time, wait, we need to fast forward through this or skip over this.
Yes, Your Honor, that is correct. And in the state's brief, I outline that for you.
Okay.
In addition to Your Honor providing a curative instruction, you then provided the jury their instructions that they are only to follow the law of the court. Okay, so moving along. To the expert witnesses. We've kind of already touched on this, but I'll just go back to some of the things that you testified to that I wanted to ask you about. You testified that you spoke to someone in the medical examiner's office, and that was the investigators. Do you recall how many you spoke to?
I don't.
You don't? Okay, but you did speak with an investigator, at least one.
Oh, yeah, the medical examiner's office investigator who testified, I spoke to him before trial.
Okay, and then you testified today that it would have been useful in hindsight to bring in the medical examiners who took a very different opinion than Dr. Henninger did about the cause of death in this case.
Yes.
I'm curious to know what additional information do you think they would have lended that would have been helpful in this case in light of the report that basically you said was helpful to this case?
I think they could have given voice to what the problem was with the finding of the manner of death and why specifically they could not establish it as being a homicide.
So let me ask you this. If you can recall, when you cross-examined Dr. Henninger, did you not probe him about these things?
I did.
And do you feel he was forthcoming?
To a certain point, but he was of the other opinion. He believed that the cause of death, he was very clear on the differences between manner and cause of death. The cause of death was a variety of natural causes, plus self-neglect and neglect of others, or by others. The manner of death, whether it was a homicide or self-inflicted or natural causes or undetermined, he was of the opinion it was a homicide. So it would have been helpful to get somebody whose opinion and he explained why he thought it was a homicide. I think it would have been helpful in retrospect to get the opinion of somebody in that same office who examined the same evidence and came to the conclusion that it was not a homicide or was undetermined. They couldn't determine from the evidence that they had. And the reason is they could put voice to it. They could let the jury hear another side of it.
So let me ask you a more direct question then. When you questioned Dr. Henninger, did he not testify about his colleagues that took a very different view than he did with the cause of death?
He did. He
Okay.
did, but he didn't say why. He couldn't get into he didn't get into the details of what was going on inside their minds and why they came to their conclusion.
But the jury was able to hear that there were colleagues of his
Yes.
qualified that took a very different approach or found a very different conclusion than he did.
Yes.
At the time, did you feel that that was sufficient?
At the time I did.
Okay. You testified that your office had a very limited budget and that you had already employed Dr. Sperry, who was very qualified. You testified to that. If your office would have had the means to hire additional experts at that time, with what you thought, would you have hired or sought to bring in other experts?
I did seek to bring in other experts, and we got together and decided that we just weren't going to get anybody who was going to be helpful.
Okay.
You have to keep in mind, this is still at the tail end of COVID, and many forensic pathologists were very, very busy, and they were very backed up, and we just couldn't find anybody who was willing to take the job on.
Okay. And can you just, for clarification purposes, why didn't you elect to call Dr. Sperry?
His testimony was useful in the where it came to the missing evidence. Once the evidence was found and he reviewed it, he was like, I just don't see any other conclusion other than, yes, he had dementia. Nobody's disputing that fact. She had dementia. Nobody's disputing that fact. It just wasn't a direct cause of death.
So is it your testimony that you didn't feel his testimony was as helpful as you thought it would be?
Correct.
All right. Moving along to the arrest warrants. You testified that you believe the warrants in this case had sufficient probable cause. And they didn't appear to be any issues.
To clarify, they weren't really on my radar either. I was dealing with preparing for trial.
Let me ask you this. At what point in this case did you file your entry? You said there were multiple attorneys.
I want to say it was, the case had been up on the trial calendar many times with Judge Downs, and had several prosecutors involved, several defense attorneys. I filed my entry, I believe, in July or August of 2018. Pretty soon after I came to the office, I reviewed the file, and that's obviously the first thing I'm going to do.
At what stage? So let me ask you this.
So you had it for almost 4 years.
Yes.
Okay.
Do you recall if at that time motion hearings had been had?
I don't think any motion hearings had been had, but I can't say for sure. I don't remember.
So you testified that you thoroughly reviewed the evidence in this case. Did you have an opportunity to look at the warrants at issue?
Yes.
Okay. And at that time, did you see anything that was alarming with those warrants?
I didn't see anything. I thought they were valid, and I thought there were probable cause for both.
Had you saw something that you thought was alarming, would you have tried to challenge, in essence?
I would have sought out I'm sorry, go ahead. Finish your question.
Go ahead.
I would have sought out the best way possible to attack it. Maybe motion suppressed, maybe not.
Okay. All right. I want to talk to you briefly about the state's comments that they made in closing argument. You testified that you believe you should have objected. Can you please tell me why?
Could you point me to where I should have objected? I don't remember. We just talked about it.
Yes.
There was a lot of, I did object to some things in that closing argument, but this was something I did not.
I believe this was the issue that was raised in reference to the state making comments about the jurors. The jurors during voir dire had made some comments in answering questions, and the state kind of touched on that in their closing. They were encouraging the jury to basically apply the state's argument as common sense in this case. You testified that you should have objected. I would like you to explain to us why.
All right, why I didn't object is I missed it. I didn't hear that it came from the voir dire. What the problem was that I don't think the jury, I don't think that's appropriate for closing argument.
And why do you think, I don't know the answer. And if Judge Hort raised it, there's probably some case that says that that's not proper. But apart from Judge Hort having flagged it, why if it's something that the jurors heard in court while the lawyers were present and the defendant was present, why, what would your basis be other than standing up and saying very knowingly, Judge, that's improper? What about it is improper?
I don't know if I say it all that knowingly. What I feel is improper about it is I don't think the jurors necessarily all hear that. Remember, the jurors are examined in panels. It's not evidence under oath. It's not
Certainly not.
instructions from the jury. It's extrajudicial. I don't think that's appropriate for closing argument. And I
Okay.
probably should have been aware of that.
So, were your reasons in not objecting strategic at all?
No, I just missed it.
Okay,
I should have objected to that.
okay. Okay, moving on. Actually, let me go back. Stay here a little bit longer. The comments that you feel you should have objected to, do you feel they were harmful?
In light of the evidence that was admissible, no.
So I'm curious to know why you feel there was a need to object.
Because I don't like evidence that's coming in being just talked about in closing argument.
Okay,
Not that I don't like it, it shouldn't be. That's extrajudicial.
and I just want to make sure that, because you said you didn't recall, are you aware of the actual excerpt that appellate counsel is taking issue with that we are referring to?
I haven't seen the transcript and I definitely do not remember the entire, what exactly was said.
Okay, Your Honor, for purposes of just, recalling his memory, this was volume 6, pages 66 through 67 of the state's closing. Would the court permit me to read the small excerpt, or would you prefer that I show counsel the actual transcript, let him briefly look at it and refresh his recollection that way?
66.
Volume 6, pages 66 through 67.
Let's all look at them. I'm going to share my screen. All right. So is that the page? That's 60. I want to make sure I got the right volume and everything. Am I on the right page, Ms. Eaglin?
It's going to be, are you in volume 6?
I believe so. Let's go back to the beginning of it. This is volume 6 of 6.
Okay.
And that was whatever was up there was definitely closing argument.
Yeah.
Okay. I believe that it starts at ladies and gentlemen, we were all in jury selection.
Let me look at 67.
I believe that's.
Here we have on page 35.
Well,
We're all in jury selection is the first line on 67, and it's a sentence that begins on 66.
Okay, there we go. All right, that's why we're missing it. So,
Sorry.
so we don't need to see 66. Here's page 67. So why don't we read quietly to ourselves? Mr. Chamberlain, do you need me again?
Sir.
Come right over here.
Your Honor, if I may, I believe it's also stated right in the amended motion.
Okay,
What was
but here we've got the transcript.
Let me see.
Do you want my computer?
No, come here.
maybe not the next one.
This is the first
Yeah,
reference to
I'm
jury
having to
selection.
do it, but I think she could see him sooner.
Yeah, she can see it sooner. That's why I said I can move.
Yeah, I put her,
I put a note.
It occurred.
okay, that's good. And she and I can talk if there's an issue, but she's not gonna mind. I appreciate you pushing it.
You're welcome.
Thank you.
Take care.
Why would they object to the state doing exactly what they did?
What page was that?
35.
Okay. And what exactly on 35?
And we even heard about how people vote in different ways during jury selection. Let's see, 46.
Mr. Corn, when you've had a chance to read, if you need me to go on to the next page, or if you've seen what,
I think I've seen what is being referenced.
okay,
And is that volume 6?
Yep, and the first,
Do you know what line that is?
all four of these first references,
Okay.
all four of these are all the defense are closing.
Okay. Alrighty, I would also, Your Honor, if the court would allow us to now go to same volume, pages, starting at page 35.
and so we're clear, page 66, 67, that was Ms. Hilton's opening, closing argument. It was not, or make sure Mr. Corn isn't being confronted with his own recitation of what juror said in voir dire. That was Ms. Hilton.
Correct.
Okay,
Correct. So I just wanted to make sure that he understood the excerpt that's at issue.
sure.
Because he testified that he didn't recall, and for purposes of the record, I want to make sure he has a clear understanding of what we're talking about. So actually, I'm going to go back and address this a little more. So now that you've refreshed your recollection, do you still feel like you should have objected to the statement that she made?
I don't think it's appropriate to discuss what some jurors may or may not have said during jury selection. I should have objected to that.
Thank you. Your Honor, if we can go to page 35,
There.
Okay, we're there.
if we can go to line 7. Mr. Horn, can you briefly read to yourself? And let me know when you're done.
Is this still Ms. Hilton's
No,
closing?
this is actually statements made by Mr. Korn.
No.
Ms. Jinks.
It was
Ms. Jinks, I'm sorry.
You didn't object to your colleague's closing.
Didn't.
If we could now go to page 46, line 24.
Did Ms. Jenks deliver the entire closing? Or, okay,
Okay, can we
Again, I didn't object to that.
go to page 48, line 2?
and so I'm clear and the record is clear, 46 and 48, are those still defense closing?
Yes.
Okay, so Ms. Jenks, not Mr. Korn, but his colleague, his trial partner in 3 different situations, 35, 46, and 48, is referring the jurors to things they may have heard during jury selection.
Correct. And
Okay.
also on page 49, line 1. Specifically, in some of those instances, the jurors' thoughts as it concerns family members in similar situations.
Is this a question?
Yes. So my question is, you testified today that you feel that you should have objected to the state's comments. Yet your colleague, in closing, referenced some of the same things.
Yeah.
Do you feel that that was proper?
I feel that that's Ms. Hilton's job to object, not mine.
Well, I wouldn't expect you to object to your colleague's performance, but it suggests that maybe lawyers don't all share your view as to whether it's a maybe proper as opposed to contrary to the rules of evidence. Other than what you've shared with me before, that you think I think the phrase you used was extrajudicial. And we certainly don't know, especially if it happened in panels, that the people to whom these lawyers are speaking actually ever heard those things said. Those would be the reasons why you would object had you thought to object, not to Ms. Jenks, but to Ms. Hilton during her presentation. Okay, I think I understand it.
One last question. In your professional opinion, the comment that you say you should have objected to in the state's closing, being that your colleague referenced some of the same things, how harmful do you believe the state's comments were in this case?
I would not say they were especially harmful, just not especially proper.
Okay, moving along. Want to talk to you about the jury charge regarding an abandoned and malignant heart that's at issue. You testified that you weren't aware that the law at this time was, I believe there was a reference to an appellate counsel's brief, bloodthirsty, as
A case from 1944 or 41. I mean, I'm sure it's still good law. I don't know that today we would say bloodthirsty either, but 80 years ago, those were the words that were used.
I would use it now.
All right.
in this particular area, no objection was made by you. And the ultimate charge that the court decided to give. Can you tell me why you didn't object?
I believe that the judge would give the pattern charge no matter what. And I had not read that 1941 case with those terms. And if I had, I might have liked to use them, but I didn't.
Do you feel that the charge was sufficient in this case?
Given that I don't think this is a malice murder case, in retrospect, I do not.
Okay, I want to quick talk to you about the juror conduct that's at issue. Do you believe that the conduct that occurred was something that was ultimately harmful in this case, and that the jurors were just unable to carry on with their duties?
Can you?
Referring to the juror who was a professional basketball player?
Yes.
I don't know what that's got anything to do with me, but I moved to strike him for cause and it was denied, and I was not going to use a peremptory on him, and he ended up sitting on the jury. When he stood up and said, "I can't follow the law," after he'd been, he could not follow the oath, I guess is what he said. I was taken aback by it, but I didn't think, I thought Judge McBurney handled it appropriately.
Okay. All right. Well, Your Honor, that concludes my questions.
All right. Judge Schwartz, do you have any redirect?
Very briefly. Going back to the cell phone in the interview room, would you agree that much of the state's case was to show that Mr. Rooks was a non-caring, unsympathetic person? Here, his mom just died and he's on the phone talking about, can I get this, do this, whatever, all these type of things to show, I guess, in essence, that not only non-caring, but that malignant heart.
Yes. Now, keeping it in mind at the time, he did not get a warrant for malice murder. So we weren't even thinking, I don't think anybody was thinking in terms of malignant heart at that point. It was re-indicted later on to include the charge of malice murder.
Were you his attorney at that point?
I was not.
Okay. And so you were not even involved in the case at that point?
No, I don't think any attorney was.
Okay. Turning to the missing evidence, the slides, the brain, whatever. Is that any reflection on what we've talked about before, whether something's missing from the transcript or missing documents or anything of that nature? Did you see that in this case?
Again, I haven't seen the transcript. We litigated that pretty thoroughly pre-trial. I'm sure there's transcripts of that. I know there's transcripts of that because that transcript I did see. It seemed accurate to me.
But I guess you didn't see other red flags that there were reports that were altered or changed, fabricated, whatever.
I didn't see anything like that, no.
And obviously, at that point in time, and you be an experienced trial lawyer, that's something you probably would have noticed if it wasn't there.
I would hope so.
Thank you, Your Honor.
Anything else, Ms. Evelyn?
No, Your Honor.
All right. Mr. Korn, thank you for your time. You are free to go. Appreciate it. Judge Hort, do you have other witnesses you want to call?
Yes, Mr. Rooks would like to testify.
All right. Can we make that happen?
He's not supposed to. Didn't listen for trial.
Raise your right hand. You swear affirm that the testimony you give will be true, the whole truth, and that's what you God.
Mr. Rooks, if for health reasons you want to keep that on, you can, but you'll need to stay extra close to the microphone so we can hear you, okay?
All right.
All right, when you're ready.
Thank you. And I'm going to, did you get your full name, spell your first and last name?
Hillius Rooks, HILLIUSROOKS.
Mr. Rooks, I want to go through some of the issues that we talked about with your trial attorney. First of all, any thoughts, comments so far as what the sentence was, whether it was supposed to be life, as said in the transcript, or life without parole, as indicated in the disposition? Do you remember that, or anything you can say there?
Right, I remember 2, life without. I'm not sure which is which.
If one of them was life and one of them was life without?
Right, when I left here, it was without. The day I was convicted, it was without. A few weeks or months later, they sent me a letter. They vacated one charge and dropped it to the thing with parole.
The felony murder would have been vacated
Right.
by law in Georgia. But the murder, malice murder, the count 1, do you remember what the judge said, or whether that was life or life without parole? I'm sorry, maybe I misunderstood what you said there.
I think it was without. When I got to the camp, that's what they was asking. You have, to separate the lifers and the life with parole, the withouts and the with.
When you got to the prison, you were treated as if it was life without parole.
I was under the impression it was without, so I got in the without line.
Okay, which what about Detective Leon Parker? We've talked about his testimony, whether there should have been objections. Anything you wanted to say in that regards?
Yes, the probable cause, first of all, the staged, the pill bottles. I mean, Mom was a hoarder and he found pill bottles from 2010, 2008. I wish he had went to Publix and got the more recent prescription. I mean, these are empty bottles that he put on display and took pictures of it, I think.
So, Mr. Rooks, I want to make sure I understand your concern. You're saying that the bottles that we heard about at trial weren't there? Or you're saying that there actually was evidence of more recent prescriptions, but maybe that's not what he found?
Right, he found, I don't know where he found those. She collected plastic for some reason. She was obsessed with the plastic, but he found old empty pill bottles. He didn't find the most recent. I don't even think she was still on that medication, the one
Okay.
he found.
Were there more recent ones in the house, or did you say?
Yeah,
Okay. And your concern is one, so far as the probable cause for your arrest, not incorporating those bottles?
I'm saying fabricated facts, pretty much.
What's an example of something you think they fabricated?
The displaying of the expired bottles from years and years ago.
Okay.
Then I assume by that you also believe that's something your attorney should have pursued.
Well, I didn't see it until I saw the date of the pill bottles. I'm saying no, and they was on display. He took a picture of it. He put it on top of a cooler. He also took a picture of a walker. That's why I say it was staged. He put it all there and then took a picture of it. That was my brother's walker. Mom never used the walker. My father never used the walker. He also charged me with false imprisonment. He said our comment was maintaining a metal door. That door was there since I was 4 years old. Only thing I did was put a pet screen on it. That was done because the screen that she had a big hole at the bottom. Well, insects, lizards, all kind of stuff would come in the house. Rodents.
Anything else you wanted to add so far as the probable cause for the arrest?
Why was I arrested in the first place? I didn't commit a crime.
Your comments so far as the affidavit and the search warrant? What is of concern to you there?
What was the probable cause?
What do you mean?
Why was I arrested?
Now we're talking about the search warrant though. You've indicated to me, and we filed that as an issue, that you believe that there was problems with the affidavit and the search warrant for your residence for the house.
Other than him fabricating what he found and to get that warrant.
Okay, let's back then to my earlier question. Any comments so far as Detective Leonbacher's testimony? Anything you wanted to add there? We've talked about hearsay, opinions, narrative.
A lot of it was misleading. In other words, it was his misconception. What he thought wasn't reality.
What about what so far as the state said in the closing argument about what jurors said during voir dire? You heard today also that one of your trial attorneys also made comments about what jurors said during voir dire. Anything you wanted to say there?
I'm not understanding voir dire.
Jury selection. When you were selecting the jury, they were asking questions about the jurors, whether they were involved in anything similar to your case.
Right. They weren't selected. The ones that I thought would be helpful wasn't selected. The ones that was more on the level I was with caring for dementia patients.
Now, you've had a concern so far as missing documents, fabrication in this case. What can you say there?
The medical examiner in his own comments said something about he couldn't determine self-neglect from neglect from someone else, and that was missing in the one you sent me. I have the original, but it's at the Haiti State. I was transferred out. I think the day mail supposed to came. Mail probably came later on that day, but I was already on the bus.
You said you have something in the original that is missing in what was offered?
Right, his comments. It was missing his comments.
Okay. And that's missing in the one that was presented at trial?
The one at trial was the original. I had it.
Okay.
Mr. Cohen didn't acknowledge it. I tried to slide it to him. I even highlighted it. his assistant gave me the highlighter to highlight some stuff while the medical examiner was on the stand, but he pushed it away from me.
But I'm sorry, I'm not understanding. You're saying that something was missing from one of the reports. Which report?
The
are you
one
saying?
that you sent me was missing comments.
Okay, the one that I sent you.
Right, the one that they sent you to send me.
Okay. We've talked about whether trial attorneys should have subpoenaed other medical examiners that came to a different conclusion.
Right.
And we talked about whether they should have subpoenaed an expert so far as dementia, the effect that has on the person, on the family. What your thoughts or comments there?
Well, they had a doctor, I guess Speary. He sat there and told the jury that dementia doesn't kill, but tell that to President Reagan, or matter of fact, ask CDC about the leading cause of death. I think at the time it was the 6th leading cause. Then COVID took over and dropped it down to 7.
So, Mr. Rooks, it sounds like you didn't agree with or like Dr. Sperry's expert opinions. Did you ever point your lawyers to some other expert who had a different view than Dr. Sperry?
I didn't know any other experts. He brought in one guy. He didn't bring him in the trial because he said it was something he said that he didn't like. Mr. Cohen didn't like what he said.
Okay, but you didn't find someone who said something you liked and say to Mr. Corn, use this guy. And Corn said, I'm not going to use your guy. I'm going to use my guy.
No, I showed him the CDC studies.
Okay.
What the leading cause of death was. When they tell me, I know I didn't murder her, but dementia does kill.
Okay.
And did you talk with that, Mr. Corn, about dementia, about Alzheimer's? The
Right.
effect that can have?
I did.
Remember what you said about the conversation?
He put it up on the internet and saw the 10 leading cause of death, and dementia was right there. I also asked him when they found the results, I asked him what type of dementia and what stage, the dementia was. He didn't know. He just said there was some dementia.
And so he pulled something up on the internet when you two were meeting?
Yes.
And did any of that talk about how do you prevent this from harming or even being the cause of death?
At the time, there wasn't much study on it. I wish they used those pictures that they saw. It was meant for mom. I wish they used that for the Alzheimer's studies. Because a lot of the stuff you look up didn't compare to what I went through. Some of it, but not in detail like what they saw. Pictures. I'm no expert on dementia, but what I went through, I think some of the jurors may have went through that, the ones that didn't get chosen. And the trial was about a lot of hearsay. They didn't allow me to tell them what mom had told me about her mother. When she go through the episodes, first thing she would say, "Ooh, I'm getting just like my mom." Her mom went through the same thing. Mom died at home.
And that even happened with other members of your family?
Dementia?
Or dying, either not dying at home, wishing they were at home?
My brother passed at home. My mom's mom passed at home. My aunt on my dad's side, his sister, she passed of dementia.
So this all happened prior to your mom dying?
It was, back to back to back.
And did that affect your mom as to how she wanted to die?
It affected all of us, really. It started with my brother. He died in 2006.
So I'm gonna pause here. I'm not remembering. Did you testify at trial or did you decide not to testify?
I testified.
You testified. Okay. Any reason you didn't share any of this with the jury?
It was a lot of, I can't say this, I can't say that. I was stopped in the middle of it. And don't say what somebody else said or something.
Okay. So the rules of evidence would have been why you couldn't share that.
I don't know.
Okay.
I'm not sure if you know what you mean by
Right,
the rules.
right.
I don't know either, but I'm not sure he knows about a lot of things you've been asking him about. Well, why didn't this expert get called or that? So I'm just, if Mr. Rooks testified, then he had an opportunity to share with the jury what he wanted to, consistent with the rules of evidence. He can't talk about what other people told him. No witness can. But I'm just trying to figure out where we're going with some of this. I have no doubt Mr. Rooks has a long list of grievances about how this played out. But this isn't the forum necessarily for that.
I'll move on. Mr. Rooks, let's talk about Detective Leonbacher's testimony so far as financial records.
So he hasn't asked you a question yet. Wait till he asks the question.
So your mom had obviously financial records. You have your own financial records. He testified in essence that you were taking advantage of your mom.
That's what he testified to, yes.
And what's your response there again as to whether this should have?
Again, it's not true. They said in what you got, the transcript, that I was depositing both of their checks. It was only the check that she gave me of my father. She said, I don't want this. Jimmy would want you to have it. And that was the little $600 that I deposited. And they said I took advantage of it. She endorsed it, but they said I took advantage. Mom had over $100,000 in her savings that I
That's not something he hasn't talked to these people.
I could have
It's
taken,
not any statements that went from such as that.
along with credit cards, cars. I'm going to take advantage of my mom.
Anything else you want to offer today?
You already have this recording. It's fine.
The jury was misled, plain and simple.
Thank you, Your Honor.
Ms. Eaglin, do you have any questions for Mr. Rooks?
Yes, Your Honor, briefly.
Okay.
Mr. Rooks. Just wanted to ask a couple of questions. Did you have an opportunity to speak with your attorney about this case prior to trial?
He told y'all we talked, what, 15, so many to 20 times? That wasn't true. I very seldom saw Mr. Cohen. I could count maybe 3 to 4 times.
Prior to trial commencing and trial starting in this case, were you out on bond?
Yes.
And is your testimony today that you didn't have an opportunity to meet with your attorney?
I'm not
Much.
saying I didn't have an opportunity. We just didn't meet as much.
Okay, did you have an opportunity to speak with your attorney about this case?
Yes.
Did you all discuss what the defense would be in this case?
Yes.
Did he listen to your concerns about this case?
Somewhat. I don't think he saw it like I saw it.
Did you provide him names of people you thought would be helpful in your case?
I did.
Do you know if he spoke to those people?
He had some investigator, and when I never saw the investigator again, only that one time, and I gave him names and numbers, and next time I asked about him, the answer was he was scared of cats. That's all he said. I said, what happened to the detective? He was scared of cats.
Okay, in this case, you testified. Do you recall testifying about your brother dying at home and his condition?
Yes.
Okay, do you recall testifying about your mom's fears of being in a nursing home?
Yes.
Do you recall
I
testifying?
wouldn't say fears, but she made it plain that she didn't want to go.
But that's something you got to share with the jury.
You wouldn't tell me that's what I'm saying. They wouldn't let me say what she said. Mom said, I want to die home. I'm not going to a funeral home. I'm getting like my mother. Those were the signs. I didn't know much about my grandmother other than mom would go down in the middle of the night because she was walking around with her clothes off. That's all I know about my grandmother. Mom would say, I'm getting just like her. When she'd be on the floor playing in feces and that, I said, Mama, ooh, I'm getting just like my mama.
Do you recall testifying to the jury about your father and his condition that caused him to be in rehab at a nursing home?
Yes.
And do you recall testifying that he ultimately died while in that nursing home?
Yes,
And do you remember testifying to the jury about how that impacted you and your mother?
yes. Now, did they think Dad had cancer? Because Mr. Cohen brought it up that Dad had died. Dad had upper respiratory. That's what it said on the death certificate.
Okay, you don't actually get to ask Ms. Eaglin questions. I think what she's highlighting is that some of the things you said that you wanted to share with the jury, you actually got to share. Maybe not your mother's specific words, but the fact that your mother wasn't interested in going to an assisted living or a nursing home.
I don't think we went that far what I just told you about my father. It was just that my father died in 2012. That was it.
Okay, well, I'll be sure to look at what the record shows.
All right.
Great. Lastly, you briefly testified about your mother's medications. Do you think Detective Liam Patcher should have gone to Publix to get her new prescriptions?
Her last prescription, right.
Okay. No further questions, Your Honor.
All right, Judge Hort, anything else for Mr. Rooks?
No, Your Honor, thank you.
All right, thank you, Mr. Rooks. Deputy Gordon's going to help you get back to your seat.
No further witnesses, Your Honor.
All right, Ms. Eaglin, do you have any witnesses you want to call?
No witnesses from the state room.
Okay. Do you have additional argument that you want to make at this time, Judge Hort, in support of either evidence you've adduced today or argument you've previously set forth in your two amended motions?
No, thank you. We again would rely on our amended motions.
Okay. Same question for you, Ms. Eaglin.
Actually, no, Your Honor, the state will rest on its brief.
Okay. So, Mr. Rooks, here's what's going to happen next. I need to work through all the many arguments that your lawyer has raised, concerns and issues he's identified with how Mr. Korn performed, with things I did that Judge Hort has pointed out might have been error, and other problems that may have come up during your trial. I will enter an order that either denies the motion for new trial. I may grant it in part. I may grant it in full. If I grant you a new trial, we actually reset everything as if there never was a trial. And then I don't know that Judge Hort will keep your case. We'll get you another lawyer to represent you. That lawyer would start working with the district attorney's office to say, can we work this out? Do we go back to trial? And if the decision is trial, we do the trial all over again, hopefully without the same mistakes. If I deny the motion, then you still have a full appeal to the Supreme Court of Georgia, and Judge Hort would manage that for you. The thing that would be most different is that you wouldn't come and testify. Many of the same arguments would be raised, but they'd be raised just in this format, in a brief. And then ultimately, Judge Hort and probably Ms. Eaglin would have an opportunity to argue for about 15 minutes each in front of the Supreme Court. So denied doesn't mean it's over. It means then you move to a higher court, the Supreme Court, that would look at all these issues and decide whether, in fact, I was wrong twice, made a mistake during trial, and then made a mistake on the motion for new trial, and they can send it back, reverse the conviction and send it back for another trial. They might affirm the conviction. They might affirm the conviction, but say there was an error in the sentence. There are lots of different outcomes, but the main thing for you is either you're back here for a trial, if I grant the motion, or your next stop, but you won't be there, but the next stop for your case is for argument in front of the Supreme Court. Okay? Do you have any questions about any of that?
I got questions about the charges.
So I'll let you ask it. I don't know that that's something I'm going to answer right here. My question to you was, did you understand the process? You got that. What's your question about the charges?
The improper, it was a false imprisonment, unlawful unlawful confinement, is it the dog or the door, the metal door?
So I don't know how it was alleged in the indictment. The jury found you guilty of the unreasonable confinement of an elder person. If in the indictment, it simply said there was unreasonable confinement, but it didn't say door or dog, then the state could prove it in any number of ways. Handcuffs, door, dog, any of the above. But if the indictment said dog, then that's how they had to prove it. And that's what the jury had to find. But I don't want to engage you on that one. I don't have the indictment in front of me. I'm just looking at the final disposition, and the jury did find you guilty of the unreasonable confinement of an elder person, which is a statute I have only encountered once, and that would be in your case. So it's not something I'm real well versed in. Okay.
The first indictment was false imprisonment. It had a comment. I haven't seen the second indictment, but it was changed from the first to unlawful, from false imprisonment to unlawful, and his comment was the metal door. Anything in the metal door, he said.
Well, now I'm looking at the indictment because you piqued my curiosity. Count 5 alleges that from November to February 2016 to 2017, you willfully inflicted unreasonable confinement upon an elder person, your mother, by creating circumstances, a dog and a locked exterior door that prevented her, your mother, from being able to exit her residence. So the answer is both. They alleged dog and locked exterior door. Okay.
It was been there since I was 4 years old.
All right. There we are. I will work on this order and we'll go from there. Thank you, Judge Hurt. Thank you, Ms. Eaglin.
Thank you, Your Honor.
We don't need to sort it out today, but I think we have a couple scheduling date changes because of, I think it was on Hodges because of, I don't know if it was the transcript just got here. I know there's been some email traffic about changing the deadlines. I'll get with Ms. Hansberry, who is the one who helps me with the scheduling. Do you feel like you've got guidance right now on the Hodges deadlines, or is that still hanging out there?
We were actually briefly talking about this already coming out, and it appears Mr. Hort has a lot of cases with you, as do I, so we'll be working together a lot. And we see in a couple of our cases where there are scheduling orders in place, but there's transcripts that are still lingering. Going forward, just to help us help the court as much as possible, do you think that it would be more beneficial for us to maybe wait to do the scheduling orders until after the transcripts have been filed, rather than have to continuously amend them? Because I feel like that's what we are having to do as it stands in several cases.
So Ms. Rivers, we're off the record now. I'll work with Ms. Rivers on that because certainly neither side can do its work, and it's sequential. Judge Hort can't do his work, begin his work until he's got the transcript, and then you respond to his motion. And so I'll confer with Ms. Rivers to see what her time frame was. Typically, what I like to do is fairly soon after a trial is over and we know who the appellate attorney is going to be for the defendant, is notice a hearing. I think that the revised Rule 39 requires us to do something like that anyway. And so what we set are more aspirational deadlines initially, because Ms. Rivers is having to guesstimate when she would get that transcript done with all the others that are lined up ahead of it. So I don't mind shifting it some, but to your point, Ms. Eaglin, it doesn't help anyone to be amending and amending and amending. So it may be that we do a two-step, we get an initial estimate from everyone, and then we check in with Ms. Rivers to say, are you in a position to give a harder deadline and more realistic one for the transcript? But I think I'm required to have that initial scheduling teleconference. But maybe what we do is just set a date for the transcript only, because nothing else has to move. And then if that deadline has to be shifted, we're not having to shift all the other things. We would just, once we know the transcript is ready, then check in with the two of you to say, all right, Judge Hort, how long do you need with everything else? And lock in that. And then your date obviously just builds off of Judge Hort's. We'll see.
But answer to your question, I think we're good with Hodges.
Okay. Yeah, in fact, Ms. Hansberry just sent something saying we're good with Hodges.
Right.
Good. You better be, because she said so. All right.
But we do have a problem with Christopher.
Yes, I think I saw that. And we need to sort that out. He's going to finish his sentence before we litigate the motion for new trial. Okay, well, we'll work through that. And Ms. Hansberry's flagged all this for me. I just have been pulled in other directions and saw that we had Rooks, so let's at least do that one. But we'll sort that out.
And I think you will appreciate us too. We're going to make your most fun days in court.
Today was great.
We got done before noon.
You did. No, I'm cautiously optimistic going forward.
She's good.
This went smoothly.
Rascal.
I
So-
will try to keep my
Oh.
briefs short, but I just try to.
I like the briefs can be whatever. It's what level of granularity we go through. And with Judge Hort, I've had differing experiences. With Mr. Goolsby, it seemed like every non-objected to thing we were asking poor Ms. Primovic about. I thought today flowed more smoothly. The arguments made and preserved in the motion anyway. But we'll develop a rhythm. Okay.
While you just mentioned it, what you'd suggested about having a focus on transcripts until the transcripts come out, that is what Judge Ingram has been doing, and that's been working out pretty well. And so we'll have the status conference, the first one at 120 days and 180 days thereafter. And it's a 5-minute thing where the transcript isn't filed. And so she says an estimate of when it will be filed. And that's all that we do.
And we just push that one date out, and everything, once the transcript is filed, can be built off that. Okay. Because
what you said was exactly what she's been doing.
all right. I have to be like Judge Ingram.
No, I just want to say like.
No, it's not a bad role model. It's not a bad role model.
Her and listen to this young lady.
Yeah. Okay. We will explore that approach. There have been several trials recently, and we're going to need to have those kickoff conferences. Because of your new structure, should the emails go straight to Ms. Eaglin, and we'll always, I guess, email you as the role you've got for our circuit. And then insofar, Judge Hort, as you are, that you have resources to share with, you just need to let us know what lawyer will be handling it on the defense side, because most of these cases I'm thinking about, they're indigent defendants, so they'll be flowing through your team.
And if I may, we are off record. I was telling these folks my last official day is October 1st.
Oh my gosh.
Our office is a mess.
Yes.
And it got to the point where the ED was micromanaging and all these administrative things that make it hard to do what you need to do. The reason why I mentioned it to you is I would love to keep your cases, and that still may be possible. But I also would love it if somebody would say, hey, what's going on? We're not going back to those days again where everything's a mess, are we? I don't know if you were willing to talk to your fellow judges and see, because it's a mess again. And
On the appellate side or everywhere?
outside.
Okay. And ED would be Ms. Ali?
Yeah.
Okay.
And the problem we're running into is the Poverty Law Center is making complaints, and then other people are making complaints. So all of a sudden now we're trying to make us do things that look good on paper, but take time away. Like, for example, next week going to have to drive 3 hours to